Hi, I'm your host, Scott Cosens, in for C5 pilot Sarah Cowgill, along with Andrew Moran, John Clark, Dave Patterson, and Graham Noble. And this is The Conservative 5, an online video production of Liberty Nation News. For irony, it's hard to beat how the world's beacon for democracy is often controlled by its most undemocratic branch. The Supreme Court is back in session, and we'll hear all manner of conflicts from the zesty to the mundane. As I speak, the High Court just heard a case that is likely to significantly increase or decrease the protections we have to keep our homes private. They will also respond in some manner on the gender wars and the all-front war by progressives against anything the Trump administration does. I'll take the lead on the first case discussed here from the Rocky Mountains, which is Case versus Montana. And this is it's the exact kind of case that I am passionate about, hoping goes one way, without question. Mr. Case was in his home. Somebody called 911 and thought he may be suicidal. The police arrived. They didn't think that his suicide was imminent, which may give them an exception to the warrant requirement, although it's dodgy because the crime element there. But in any case, that would have provided them cover for entering the home. They were outside his home for 40 minutes while trying to talk to him and getting him to come to the door. And that's important because that's quite enough time to present facts to a judge and see if they would grant a warrant for the police to enter. But they never took that step. Instead, they just barged in his house and they wound up shooting him because they thought he was trying to do a suicide by cop. Now, leaving aside whether the shooting was okay, the case, and it's funny because it's called case, right? The case concerns whether or not that was a legal entry into his home. And because I'm so dedicated to the notion that we must zealously guard our privacy from the police, I'm passionately in favor of them seeing the case Mr. Case's way, as it were, as are seemingly most of the kind of liberty-minded folks who've filed amicus or friends of the court briefs. And I'm terribly sad that Tim Donner is not a panelist on the show, because on the Uprising podcast, which we used to do together, he would always remark whenever we'd talk about this stuff that the judges just sign anything for the search warrants anyway. It's not like it's hard to get a judge to sign a search warrant in 2025. It seems like they just do it no matter what. So to even have that last sort of flimsy barrier go away, it scares the hell out of me, John Clark.
Well, interesting that I'm going to disagree with you only to play devil's advocate. You might recall I spent 8 years as a criminal defense attorney, and I certainly share with you the sentiment of protecting particularly the sanctity of our home under the Fourth Amendment. But what's intriguing about the case to me, and that is that the police actually said in their defense, or to play devil's advocate for the police, is that they didn't go to get a warrant because they didn't think they were there for a criminal investigation. They were there to help him. And this is what the court is considering, whether when it's an emergency situation and the state of Montana has said that it won't work to use a probable cause standard for emergencies because that's built around criminality, whether right or wrong. But what the case really concerns is whether the government and the state need to show probable cause or a reasonable suspicion. And so that would increase the level of scrutiny applied to any police activity. And so whichever way it comes down, by the way, this is one of many very intriguing cases, as you said in your intro, coming to the U.S. Supreme Court right now. There's a very interesting...
Before I ask you about what some of the other ones are that you're focusing on, I will just put a pin in that, your comments, which I did appreciate. And I would say it's perfectly framed. Here we have the government was dispatched to somebody's house who they thought wanted to be commit suicide by cop, which is to say present some perceived threat to law enforcement, which would then allow law enforcement to enact to shoot them, basically use deadly force, and they were confident that law enforcement would. So how did they help that situation, John Clark? They dispatched police officers to the house and broke in and shot the man. And I would just say that they would be helping a lot less if they didn't help quite so much.
Well, that's quite
and that this idea that the government acts to help us is as an imposition to our liberty must be rebuffed by the courts, lest we lose all of it. And we're just going to get helped with hate speech. And not to do that, we're going to get helped with all these other things that progressives want us helped with that so many of the rest of us want the government to stay out of our business. But there's more business before the court. So please tell us what else is coming down the pike in terms of, what we're going to judge.
And I would just say to, again, look at the facts. This is a veteran, and the police could be just, this is a factual analysis for courts, whether the police were actually concerned for him. When they went in, they saw, and one of the reasons they delayed going in is they saw an empty holster on a table. He wasn't responding. They had his girlfriend had called the police on him out of concern. And then when they went in and found him, they thought he was reaching for a gun. And what he's trying to exclude as evidence is the handgun found in the clothes bin next to him. So he's trying to exclude evidence to defend himself from having potentially placed police officers in harm. And so that also there's a balance there.
You are now adding to the mix the issues that have occurred after they've breached his home without a warrant. That is the key issue before the Supreme Court, whether they can enter that home without a warrant under the circumstances that they've delineated. And you've also presented the facts in a most charitable way towards the state. And whenever we do that, we should expect the state to win. But if we present the facts, I think, in the manner that's most likely to respect liberty, we might see a different outcome. But I don't want to spend all of our time on this segment on this case. I'd like to move along to other cases. And so please go ahead and let us know what other case may be interested in this term in the court.
Yeah. So interestingly, people can read on Liberty Nation about our ongoing discussion of the Voting Rights Act and its conflict with the Equal Protection Clause. But the other big one I wanted to mention that I think is seismic for the nation is West Virginia versus BPJ, which concerns men, biological men playing in girls' sports. And interestingly, of all places, West Virginia, the state passed a law to protect women's sports. It was challenged by a transgender youth who the appellate court, the circuit court, I think Fourth Circuit, then imposed an injunction to allow this biological male to defeat hundreds of girls in track. And so
is this a high school? I don't know the facts of the case. So
it's a high school. I believe it's high school level. And that's why the
high school in West
And so now 25 states, I believe, have passed similar laws. So it's split right down the middle. And meantime, the Supreme Court refused to hear a case, Lee versus Poudre School District, which concerned parents complaining that their children had been indoctrinated to change genders, and that was concealed from the parents because there was a lack of official school policy. This case is seismic for the transgender battle in the country right now and for women's rights. And it's pitching the Title IX against the Equal Protection Clause. And so, we can all speculate on how that comes down, but that's a case to watch.
This is one of those things where we've got two lawyers talking to each other about a complicated issue. So I don't want to get too lawyerly with people, but I do want to, I think this is a crux question. Isn't there room to decide on either one of these bases? Meaning, like, let's just say hypothetically, we think that Justice Sotomayor may have a certain way that she's going to think about these issues, and maybe Justice Kavanaugh as a different way that he's going to think about these issues. But isn't there a way for both of them to have the same opinion for the outcome, grounded in both deciding that Title IX guarantees that a male who transitions can play this game, or that he may not be able to, or that the Equal Protection Clause prohibits that or mandates it?
Yes, exactly.
Okay.
And actually, the dissent in the appellate court emphasized that the district court or that the fellow judges on the appellate court were misconstruing both Title IX and gutting the Equal Protection Clause at the same time. So the two, and of course, the Equal Protection Clause is supreme law of the land and supersedes any conflicts in Title IX, as a reminder. But either could be.
Let me just stop you right there. Sorry. I want to put a pin in it just because we do have an educational mission, and it's important to remind people sometimes of these things that the Equal Protection Clause is written into the Constitution, and Title IX is a part of the body of federal law. It's not included in our Constitution. That's why it's supreme. And if there's a conflict, they have to rule that, on the Equal Protection Clause side of things. So I apologize for the interruption.
No, but that's what I'm trying to say. So likewise, in the cases regarding the Voting Rights Act versus the Equal Protection Clause, people are up in arms against, gutting the so-called gutting in the headlines, the Voting Protection Act. But the Equal Protection Clause is paramount. There's equity and then there's equality.
Okay. Graham.
Well, I'm just going to, with regard to the first case you spoke about, and my view is that, like vampires, police officers should not be allowed to enter any private business or any private residence unless they have express permission to do so. I don't care if they got a warrant or not. The only exception I see is if they're standing at the door of the house and they hear screams or gunshots in the background. Then, yeah, by all means, go ahead and go in. But otherwise, they shouldn't. To me, the idea of police ever, on any occasion, for any reason, busting the door down and going into someone's house is just, as far as I'm concerned, it should never happen.
It's so delightful that you chose to emigrate to the United States of America, by the way. You could have gone anywhere, and you came here with your pro-freedom message, so thank you so much for that.
I know, right. Well, you're welcome, yeah. And I just throw in very quickly that, to me, it's a matter of the safety of the police officers as well, because it is dangerous inside a house or inside any building that has multiple rooms and hallways and stuff, and you're confronting people with guns. That is a dangerous situation. Always better for the police. If they think there's somebody in that house they need to arrest, just wait outside the house, because sooner or later that person is going to come out and then you arrest them.
Andrew, I know that the U.S. Supreme Court isn't at the top of your agenda items, but perhaps there's an economic issue that I haven't seen come across the bow that you want to weigh in on, or some other thing?
Actually, yeah, there surprisingly is, and I'm monitoring it closely. And I'm not going to pretend to be Clarence Darrow, but there's one case happening in November. Remember the 5th of November, and it's actually the SCOTUS is going to hear oral arguments in the Trump tariff case addressing the legal challenges of the 1977 International Emergency Economic Powers Act regarding the reciprocal tariffs. So that's one case I'll be monitoring.
Have you read the briefs?
No,
well, we'll look forward.
I defer to you for that.
We'll look forward to a future report on you regarding that. Thank you very much. Dave, let's turn to you and your analysis on any court items you've been watching.
So I think that I dwell a little bit on the men and women's sports, and this has become a most difficult subject, because it is a circumstance where people who object to Title IX and say that men should be able to play in women's sports are calling black white and white black. Those kinds of arguments are the most difficult kind to get your head around. In fact, William F. Buckley once said, when he had interviewed Madeleine Murray, the famous atheist, he said, "I will not have her on the program anymore, because you cannot have a discussion with someone who calls black white and white black, because there's no standard for logic." And it's the same thing with this issue of transgenderism. A man has 36 trillion cells, all of which show XY chromosomes. Women have 34 trillion, all of which have XX. There is no center. There's no either side. That's just the way biology is. And we have come to a circumstance where the transgender crowd has so muddied this issue that we're trying to define black as white and white as black.
All right. Well, we'll leave it to our bettors on the court to tell us how we're going to have to live under these terms. Thank you so much, panel. That's it for our Conservative 5 panel today. Check out our other C5 shows and segments on your favorite video platform. YouTube, Vimeo, Rumble. We're on them all. Liberty Nation News has its own Roku channel as well, where you can see all of our videos. Liberty Nation does not endorse candidates, campaigns, or legislation, and this presentation is no endorsement. I've been your host, Scott Cosenza, in for Sarah Cowgill. Thank you for joining us here, and for the latest news and commentary, your choice for free thinking, free speech, LibertyNation.com.